Hello, everybody, and thank you for joining us for our webinar today. I am Clayton Hearn. I am one of the shareholders of the firm, and I work out of the Dallas office, yet many of you around the state have probably spoken to me before because in addition to general POA work, my practice involves focusing on fair housing issues. And I'll be talking to you today with Koirtyohann, who is one of our associates in the firm, who is on the same team with me when it comes to fair housing advice that I've maybe given to many of you, or you may have heard from me. Often it can be bad news, and we'll get into that today. But with the introduction, we'll turn it over to the inevitable disclaimer. It wouldn't be a legal seminar given by attorneys if we didn't tell you that we're only basing today's presentation on the law as it exists as of today, and this is for educational purposes and should not be considered a replacement for legal advice tailored to your very specific issue. So with all the disclaimers out of the way, I will turn it over to Ashley. But first, I'll kind of introduce the topic. We're going to be talking about emotional support animals. Sometime when we get rushed, we'll refer to them as ESAs. And the sort of question title to this is, can POAs follow the airlines and restrict emotional support animals? For those of you who only have a few seconds to join us and might have to nod off or get on another call, spoiler alert, the answer is no. But let's talk about the agenda and kind of what we're going to go over in today's presentation. We're going to talk about first the Fair Housing Act, because emotional support animals, the whole existence of the concept is embedded in fair housing, and that's how it applies specifically to our industry. We'll talk about emotional support animals, what an emotional support animal can be, what it can't be, and what the burdens are, and how, as POAs and managers, we evaluate accommodation requests. We'll also talk about unique animals. You've all seen the comfort duck flying on airlines, and people have comfort lizards and so forth. So we'll talk about some of those unusual animals. Seems to be a trend now for chickens. That's a big deal. And the direct threat exception, and how you treat and how you deal with ESAs in common areas such as the pool area or a lobby of your community. And then I will talk about some government attempts to sort of curb some of the abuse, because we've all seen some very questionable accommodation requests when it comes to emotional support animals. So with that, I'm going to turn it over to Ashley. And again, thank you all for attending.
Hi, everyone. In true 2020-2021 fashion, I'm joining you from my home office, so hopefully you won't hear my cat in the background, who is not an emotional support animal, as great as he is. As a general sort of recap of the Fair Housing Act, as it relates to issues broader than emotional support animals, it prohibits discrimination against people based on certain protected classes in connection with housing. Those protected classes under the Fair Housing Act are race, color, national origin, religion, sex, familial status, and disability. The most important for today's discussion is going to be disability, because that is the protected class that sort of gives way to reasonable accommodations for emotional support animals. A lot of people tend to think of the Fair Housing Act as applying to the sale or lease or rental of a dwelling unit, but the reality is it applies to pretty much any sort of housing related activity, which is where our POA clients get brought in. The housing related activity that they engage in is the enforcement of rules and regulations, and that's sort of what births these reasonable accommodation requests. And the Fair Housing Act says that these housing providers have to make reasonable accommodations that will allow persons with disabilities to fully use and enjoy their dwellings. And that's sort of where we get into these questions about emotional support animals. The when we get a question that from a client or anybody that appears to implicate the Fair Housing Act, there are a couple of places that we look to kind of figure out an answer. And the first is obviously the text of the Fair Housing Act itself. And it's worth mentioning here that there's the Federal Fair Housing Act, which is what we usually talk about. There's also a Texas Fair Housing Act. That one is administered by the Civil Rights Division of the TWC, but because it so closely mirrors the Federal Fair Housing Act, typically if you're complying with the Federal Fair Housing Act, you're complying with the Texas Fair Housing Act. And the text of those statutes is fairly static. It changes very infrequently because changing the statutory text requires Congress to pass an amendment. It's a very long, burdensome process. So, the text stays largely the same. The last major amendment was in 1998. So we haven't seen a lot of updates in that area. The problem with the statutory text is twofold. One, it can't account for every possibility. It can't account for every situation. It doesn't give a lot of detail in that respect. So it sort of gives you these general guidelines. And then sometimes it's not clear how those apply to the specific situation that you're dealing with. The other issue being that, like I said, the last amendment was in 1998, and it may not have contemplated changes in disability services, in therapeutic treatment and things like that. So very often we'll find that the statute of the text doesn't really tell us what we need it to tell us. So from there, we look to guidance, and guidance is issued by the agencies that are responsible for enforcement of the Fair Housing Act. And those are primarily the Department of Housing and Urban Development and the Department of Justice. And like I said, the Texas Fair Housing Act would be the Texas Workforce Commission. And guidance is issued much more frequently than you see any sort of changes to the statutory text. Frankly, the tone of guidance changes depending on the administration that's in office. We are unlikely to see any really any housing provider friendly changes in the next 4 years. But in that sense, it does change. It'll completely contradict itself every few years. And really what the guidance does is it says, this is what the text says, this is what we think that means, this is how we're going to enforce it, this is what you're allowed to do, what you're not allowed to do. And here are some examples of situations where we might consider something to be housing discrimination, or examples when we might not consider something to be housing discrimination. So that's much more helpful for looking at a specific situation and saying, if this homeowner went out and filed a fair housing complaint today, how would that likely turn out? So we do look at guidance pretty frequently. Probably, most of us are pretty familiar with the fair housing text by now. So, where we're really looking is to see, has the guidance updated since last time, we've looked at this question. And finally, if there's really no answer in the guidance or in the statutory text, we'll look to, or if the guidance is unclear, we'll look to case law. Case law is less predictable in the sense of it's more predictable for something that's in litigation, but it's less predictable as to what would a fair housing investigator do with this ruling, particularly if it's in a court in another jurisdiction. So the most helpful for us is typically the guidance. And I mentioned earlier the obligation to grant reasonable accommodations under the Fair Housing Act. For those who are unfamiliar with that term, a reasonable accommodation is a change, modification, adjustment to an existing rule or policy that would be necessary for a person with disabilities to fully enjoy their dwelling, as well as common spaces. That includes amenities and general common areas like lobbies and hallways. The reasonable accommodation really relates to, in our context, the way that a POA enforces its rules. So typically what we see is a homeowner asking for an exception to a pet-related policy. And so with respect to emotional support animals, what we usually see is an individual with a disability requesting to keep an emotional support animal in their dwelling and to have it accompany them in the common areas. And the guidance from HUD pretty explicitly says that this is, in most cases, going to be a reasonable accommodation. So what does this mean for POAs? POAs, as I said, are viewed as housing providers in the sense that they regulate housing. And they're responsible for evaluating and responding to these requests in a way that complies with Fair Housing Act. And sometimes it's not obvious or arguably common sense the way that the Fair Housing Act requires POAs to respond. The most frequent we see is, I would say the most frequent accommodation request we see, period, is a request to keep an emotional support animal that has really skyrocketed over the past several years. ESAs, it's important to know, are not considered pets. HUD guidance basically says these animals, well, they're careful not to call them service animals because that is something different. They're not pets either. They provide emotional or therapeutic support to disabled individuals, and the owners are generally entitled to exceptions from pet-related rules, and those are going to be breed restrictions, weight limits, limitations on the number of pets, and pet fee requirements. So now that we've covered that, Clayton's going to talk a little bit about how you should evaluate these requests as they come in.
Yes, thank you, Ashley. That was great. So the National Service Animal Registry sounds very official. It seems like something maybe the federal government under the auspices of HUD keeps track of. Unfortunately, it's just a volunteer website. So you all have probably encountered at some time or another in what I'll call an ESA letter, but a letter from a treating physician related to an emotional support animal request. While Ashley was talking, I actually registered her cat as an emotional support animal for both my house and hers. So, and I say that joking, and I really didn't register her animal. However, it probably takes just slightly more time than that to obtain a letter that complies with the HUD guidance. So this National Service Animal Registry, I've received requests several times that says this animal is, certified number such and such, and it's a 10-digit number. That doesn't necessarily mean that that animal meets the definition of an emotional support animal in the context of your POA. So that's something, it's not definitive, but at least it's a starting point. If they're registered on this website, at least they've gone through some steps to go online and get this animal registered. But as we all know, and kind of the point of this exercise in this presentation is, there are always going to be unfortunate attempts to kind of use this law to skate the rules of your community. There's a weight limit in a condominium of 30 pounds. Someone comes in with a St. Bernard. Lo and behold, they come up with an emotional support animal documentation from some physician saying that they suffer from some kind of emotional issue. So the efforts to skirt rules applicable to pets is something that we all become skeptical of and have experienced some kind of abuses. So we will now turn to what actions a POA can take. And once a proper request is made and supported by documentation, a POA cannot ban or prohibit an ESA as long as that ESA isn't dangerous or pose some kind of risk or otherwise is disallowed under the HUD guidance. So you can't also base a denial of an accommodation request on the dog's breed or the breed of the animal. I know we've all encountered stories of pit bulls and how they might be inherently aggressive or more likely to bite. There are other breeds that are associated with that. You cannot have an outright breed ban. So you have to look at the individual breed and determine if that, the individual animal, I almost said pet, which we just taught you shouldn't be doing, you have to have the aggression or the dangerousness of the specific animal that you're looking at. So when you're evaluating an accommodation request, there are a lot, the slide breaks all of our rules about having too many words, but this is the key pivotal point when you're looking into an ESA request. You have to be able to request documentation when it's allowed. And oddly enough, or not, maybe not oddly enough, the rules, the HUD guidance on evaluation of an accommodation request are fairly intuitive. So the first one, if the disability and the need for an assistant animal are both readily apparent, the POA should not ask for supporting documentation. And I'll give you an example that relates to service animals, not necessarily emotional support animals, and that is you have an owner, he's wearing dark glasses, using a white cane, walking around with a dog that has a vest on it, that's red and has some language about being a service animal. You probably don't want to seek supporting documentation for that unless you have some real reason to suspect fraud. And that's the most illustrative example I can think of for the first level of guidance. But really the summary of all the other ones is when something isn't apparent about the request, and the two areas that you evaluate are, is there a disability, and does this animal alleviate the symptoms or severity of this disability? If those things aren't readily apparent, then you can require support documentation. And in the context of an emotional support animal, it's going to usually relate to a mental or an emotional disorder or condition. Those are typically not going to be as readily apparent as the person with the white cane. So in most cases, you will have the ability to seek support documentation, but what you can't really do is dig into that support documentation and look for medical records. And I'm stealing a little bit of Ashley's thunder because she's going to go into more detail on that. But you can ask as a housing provider, you can ask for documentation from a physician, psychiatrist, social worker, or therapist that says, this person is under my care, or I've treated this person and they have a disability, and this animal alleviates some of the effects of that disability. So with that, I'm going to turn it back over to Ashley so she can get you some more granular detail on some of those points.
Sure. So one of the things that I think you alluded to that a lot of our clients struggle with is, you can almost always find a doctor who's willing to write you a note that meets these requirements, because basically all it needs to say is, I've treated this person, which we all know in this era, basically you could do a video conference with a doctor. I'm treating this person, they're considered disabled under the Fair Housing Act, and they need this animal to assist them in their daily lives in connection with that disability. And once an association has that in their hands, there's really not a lot that they can do to challenge that. You might think, well, God, this person just went out and found like a random doctor to write them this note. And that may be true, probably in a large number of cases. But in terms of documentation that's going to satisfy a fair housing investigator, that's all they really need. You're typically not entitled to ask for any sort of detailed medical records. You can't say, well, we want to see your therapy notes, or we want to see details about your diagnosis or the medications that you're taking. You're typically almost never going to be entitled to that sort of information. And sometimes a note, well, it's less likely in the context of emotional support animals, but in the context of service animals, there could be situations in which a doctor's note isn't even really required to establish that the person is disabled. They might be receiving Social Security disability benefits, and there is some guidance to suggest that alone is sufficient to establish that the person is the individual is disabled for purposes of the Fair Housing Act. So we hate to tell clients this, but in a lot of ways, once somebody has provided a really bare bones document from a doctor or another treating person, your hands are kind of tied in terms of questioning whether that person is entitled to an emotional support animal. At that point, you turn to questions about whether the animal in question is allowed. So luckily, we've gotten some new guidance lately about the types of animals that are allowed. There is some older guidance about what to do if the animal in question poses a direct threat to the health or safety or property of others. So those are pretty much the two questions. Once you've established that somebody is entitled to have an emotional support animal under the Fair Housing Act, the next question becomes, does the animal itself qualify? And our next slide is going to talk a little bit about this new guidance for common household pets. There's some relatively new guidance. It's not super new, but it's come out in the past, I want to say year or two, that says HUD is going to consider emotional support animals to be allowed if they are these common household animals. And it's funny because we said earlier that they're not pets, but the language that HUD uses is this animal a common household pet? And the lists that they provide, these lists on the side are pulled directly from HUD guidance. And those common household pets are considered dogs, cats, small birds, rabbits, hamsters, turtles, and other small domesticated animals. And then they give some examples of animals that would not be considered these household pets. And I think the one that a lot of us as fair housing lawyers were disappointed not to see explicitly called out is chickens. Clayton alluded to this earlier. We have received just frankly a surprising number of requests that relate to chickens. If anything, it's increased recently. I would say I personally worked on about 4 emotional support chicken questions in the last quarter of 2020 alone. And the problem with this list is that, a homeowner who wants to keep an emotional support chicken is going to say, well, chickens are small birds. And our argument would be chickens are barnyard animals. Nobody really keeps chickens in their house. They're animals that are kept outside. And it's a little unclear from this guidance. And the problem we've run into is that, and maybe this is a good chance to mention that in a lot of cases, in different areas of law, when something is required to be reasonable, what it really means is would an ordinary person find it reasonable to do X? But in the context of fair housing, what ultimately matters is would HUD or the TWC or the Department of Justice determine this is reasonable? That's a very different question because, for example, our firm handled a request a couple of years ago from a woman who wanted to keep 6 emotional support chickens in her yard. And the association pushed back a little bit. Ultimately, a fair housing complaint was filed. And our position was that's not reasonable. It's not a reasonable accommodation to say you need these 6 emotional support chickens. But ultimately, when we went to conciliation in that claim, which is just a fancy fair housing word for mediation, the mediator contacted the division director of the TWC, who came on and told us, I think that's reasonable. 6 chickens is reasonable. And if you don't let this lady have her 6 chickens, we're going to issue a for-cause finding against the association. So while an ordinary person might not consider 1 chicken, much less 6, to be a reasonable emotional support animal, we have at least one instance where the decision maker in that case has come back and said, yes, that is reasonable. So at this point, until we have clear guidance saying chickens are not these common household animals, our experience has told us that chickens are generally going to be allowed, and we're not sure what the number, what the cutoff would be for the number that HUD or the TWC is going to consider reasonable. We know it's at least 6. So it's hard to say. There is not a bright line prohibition on this is the number of animals you're allowed to have. Anything more is not reasonable. So those are really made on a case-by-case basis. And frankly, it's hard to guess what an investigator is going to decide. As of right now, we know it's a number higher than 6. The other question we run into is, are there any situations in which somebody might be allowed to keep an animal that's not a common household pet? And the answer is yes. HUD guidance suggests that once it's been determined that somebody's entitled to an emotional support animal, if they're requesting to keep an unusual or a unique animal, the requesting individual has the substantial burden of establishing the disability-related need for that specific animal. They use the word substantial burden in the guidance, but then they go on to basically say if they have a doctor's note that says that this particular animal is needed for a disability-related purpose, you can't push back on it too much. However, the example they give is unlikely to apply in the situation of an emotional support animal. The HUD guidance gives the example of a paralyzed individual who needs a service monkey because the monkey can open his medication bottles for him when nobody's around. And, a dog or a cat doesn't have the ability to, the dexterity to open a bottle. So in that case, he would be entitled to that monkey. But emotional support doesn't really require any certain level of dexterity or any really animal specific qualities. So it's difficult for me to imagine a situation in which somebody could come in and say, well, I need this emotional support monkey because a cat won't cut it. But we haven't really seen that come up too much in our practice yet. The most unique animal we tend to see is a chicken, as we already discussed. There's also a direct threat exception that can apply to unique animals as well as common household pets. It basically says, and Clayton alluded to this with the pit bull conversation earlier, the exception basically says that you can't assume that an animal is dangerous just because of the type of animal or the breed that it is. You can't say, we're not going to allow your emotional support dog because it's a pit bull. But if you have evidence that that particular animal has shown signs of aggression, has bitten people, has these sort of issues, then if that threat to health and safety can't be mitigated by another reasonable accommodation, which might be, okay, you can have this animal, but anytime it's in the common areas, it has to be muzzled, or something like that, then you do have the ability to say, you can't keep this dangerous animal on our property. I have not seen that issue arise yet. I'm sure somebody in our firm has, but in theory, if you had a dog with a history of biting people or a history of lunging or these other sort of dangerous behaviors, then you don't have to allow that person to have that animal in a situation where it might be able to harm other people in your community. In addition to the threat caused by a dangerous animal, you also can exclude animals if they pose a substantial threat to the property of others in the form of physical damage. It's hard for me to imagine what that might look like. The best example I can think of is when I was in college, I worked at Target, and we had a woman who would bring her horse. She had a service horse. She was a disabled individual. And we would open the store early for her, and she would shop horseback. And the issue was that, we were concerned that the hooves were going to tear up the floor, but she mitigated that by putting these like special booties on the horse so that wouldn't happen. If somebody was going to bring in a large animal that you're worried is going to just tear up the common areas, that might be a situation where you could evaluate whether it's entitled to this direct threat exception. Unlikely, but possible. And I think from there, we're going to talk a little bit about ESAs in common areas. We get a lot of questions about whether or not we have to let people have their emotional support dogs. It is dogs more frequently than any other animal in the pool area. And, with this weather, probably nobody's thinking about that today. But as we get, closer to warm weather season, we'll start getting more of these questions. Generally, emotional support animals are allowed in the common areas. That's going to include in a condo, things like the amenities, the lobbies, the hallways, and in single family homes, more likely going to be things like maybe you have walking trails, but also pool areas, clubhouses. They're generally allowed. the owner of the emotional support animal is responsible for kind of controlling that animal. You are typically required, or you are typically allowed to require that the animal be leashed. The exception might be if it's a true service animal as opposed to an ESA, and it has a disability related service that requires it to be off leash. We've had homeowners say that they needed their dog to be off leash before because she had, I believe it was a bad case of vertigo, and the dog would circle her and kind of keep her from walking off of sidewalks and things like that. Most emotional support animals, that shouldn't be an issue. So there's my cat. So you should be allowed to require them to be on a leash. In terms of the pool area, you do typically need to allow them in the pool area itself, the decking and wherever the pool furniture is, but you don't have to let the emotional support animal, and you shouldn't allow the emotional support animal to go into the water just because there's a health and safety code provision in Texas that says that animals are not allowed in public pools because it's just unsanitary. It can clog up the filters, things like that. So we typically, in most cases, of course, in theory, there could be a situation where that changes. We typically recommend allowing the animal to be in the pool area as long as it's on a leash and kept, under control, but not into the water. So Clayton's going to talk a little bit about some efforts that various states have made towards sort of curbing abuse of this process.
Thank you very much, Ashley, and very entertaining. I'm hoping that our audience doesn't have to deal with a horseback owner as Target was forced to do or volunteered to do. Yes, and chickens are a big part of my practice too. We had the chicken request, and that's why in all of these emotional support animal presentations, we always mention chickens, because one of our examples of a chicken case involved a woman who was hearing impaired, and because she was hearing impaired, of course, she needed several chickens. That one we were able to prevail on because there was not a nexus between the disability and the animals. So there are some limits to all of this, and it does seem like the law, the guidance in the fair housing law is geared specifically in favor of the requesting individual. So what are they doing to protect the POAs? What are they doing to curb this abuse? And fortunately, we do have at least an effort afoot to try to curb these abuses here in Texas. But right now, some states have laws that make it an actual crime for misrepresenting the status of an emotional support animal. Texas doesn't have a similar law regarding ESAs or emotional support animals, but it has made it a misdemeanor to outfit a dog as if it's a service animal, suggesting that it's a trained animal rather than an emotional support animal. But our lovely legislature, who meets biennially, is currently has a House bill pending. It's House Bill 801 that sort of codifies some of these common sense approaches. And what House Bill 801, which we're generally in favor of, it requires the owner or the primary holder, controller of this ESA, to be evaluated specifically by someone trained in mental or emotional health to certify that they have a qualifying disability. And it goes further that the animal has to be certified by a veterinarian and meet certain criteria. And then, so you got the vet, the psychiatrist, and then the state would like to form a registry that's actually an official government registry clearinghouse to register this animal and show that it's been qualified for purposes of fair housing. The problem with this, and there is that none of this House bill is able to preempt or supersede the federal fair housing law. So all of the guidance under HUD is still going to be in place. So the argument's probably, I can see the argument into my future with my crystal ball here. There are going to be people who make the request without going through the Texas Clearinghouse who will say, there is no guidance or no requirement under federal law that I go through these hoops. Therefore, the Texas law is not applicable to my condition. So that fight hasn't come up. The bill hasn't even passed yet, but it's a fight and a dispute that we see on the horizon if this House bill is able to pass. Now, the House bill as written does have an exception for senior communities. You can't have an assistance animal in a master plan 55 and over community. Makes sense. It's sort of a safety and welfare issue. So this is, at least as far as I'm aware, the first real effort underway in our state to try to curb these abuses and do away with the comfort duck, or the person who just can't afford the pet deposit, so they go online and get a service animal or a support animal certificate and letter supporting it from a therapist who reviews a narrative that they submit online and then spits out a letter. Like I said, I was able to, in the introduction of this, register Ashley's cat. While Ashley was speaking a while ago, I registered some pets that I don't even own. So there is the area and the sort of window for abuse. And thankfully, we have a state legislature that's trying to rein that in. So with that, Ashley will kind of walk you through what an FHA complaint really looks like. We've kept talking about FHA complaints and findings of cause, and Ashley will walk you through sort of the steps of what that entails. So thank you. I'll turn it over to Ashley.
Yeah, so I think this is important information for a lot of people to have, because you might find yourself in a situation where you really want to push back against one of these requests. And so it's important to know what you're potentially exposing yourself to, and so you can really make a fully informed decision and perform that balancing test for yourself. So FHA complaints can come in two forms. They can either be filed as an administrative complaint. That administrative complaint is pretty much free to file. It's a form that gets filled out. Homeowners don't really need an attorney to assist with it, although a lot of them will. That complaint will lead to an investigation, depending on the merits of that complaint on its face, not necessarily what's true, but what the complaint says. From that point, it tends to go one of two ways. Either the parties agree to participate in conciliation, which I said earlier is just mediation with a different name. But both parties have to agree to that. The Fair Housing Authority, the HUD or TWC, or whoever's completing this investigation, can't really force the parties to conciliate. Both sides have to agree. If the parties don't proceed with conciliation, then typically the respondent, who in our case would be the POA that the complaint was filed against, will prepare what's called a position statement that basically sets forth all the reasons why they think the complaint is invalid. Like I said, they're pretty much free to file. They cost the homeowner almost nothing, but they can be very expensive to defend as the housing provider. It may be covered by insurance, in which case, you're out your deductible, but hopefully not all of the subsequent costs. If it's not covered by insurance, then you're looking at attorney's fees to either participate in conciliation, which usually is a half day to full day process, plus preparation time. If it's the drafting of a position statement, those tend to be pretty lengthy evidentiary documents. So defending those claims is a lot more expensive than bringing those claims. It's in one way in which this process is skewed in favor of the homeowner. If they go the administrative complaint route, you don't settle at conciliation, you move to the position statement phase, then the investigator will ultimately make a finding, and they'll either say there's no cause to believe that a discriminatory housing practice occurred, we don't have enough information, we're dismissing this complaint, or we do have cause to believe that this has occurred. And once you have that for cause finding, that sort of triggers the ability of HUD or the state to file a lawsuit. And that's another way in which this is fairly inexpensive for the homeowner, because if it goes that direction, then a lot of the litigation costs are being covered by the government, and the housing provider is still out their attorney's fees, whether or not those are covered by insurance. Homeowners don't have to go the route of filing an administrative complaint. And a lot of these sort of statutory claims, like Title VII, for example, the complainant is required to sort of exhaust their administrative remedies before they can file a lawsuit, but that's not the case here. A lot of homeowners choose to go the administrative complaint route just because it's inexpensive, but in the event that they wanted to, they could proceed directly to litigation. So our next slide is going to talk a little bit about, if a lawsuit is filed, what sort of damages or penalties are you opening yourself up to? The first is civil penalties. These amounts, they're capped, and that cap is set by HUD each year, and that amount is adjusted for inflation essentially every year. We haven't gotten the 2021 numbers yet. They're expected in March or April, but the 2020 maximums depend on whether or not you have been found to have committed a violation in the past. So for first-time offenders, it's a little over $21,000. For offenders who are committing their second violation in a 5-year period, they're looking at closer to $50,000. And if it's the third or a subsequent violation in a period of 7 years, that jumps up to over $100,000. And it's important to note that civil damages are just one portion of what somebody might be entitled to. As we'll see on the next slide, the civil penalties are in addition to these actual damages that somebody might claim, which could be something like, oh, well, you told me I couldn't keep my emotional support animal here, so I had to sell my house and go live somewhere else. And I because I had to sell in this bad market, I didn't get as much as I could have. This is the kind of thing that they might try to argue. I'm not sure what the other actual damages would be in this case, but the big chunk of change comes in the form of attorney's fees. If the homeowner is bringing the lawsuit themselves, they have their own attorneys. If it's being brought by the government, then the government agency can seek recovery of their attorney's fees. And those can be pretty substantial. If the lawsuit goes on for years, which is certainly a possibility, not uncommon at all. You're looking at, attorney's fees for the initial filing of the complaint, for conducting discovery, depositions, for attending any sort of court-ordered mediations, for motion practice, for preparing and attending trial. It adds up. It adds up fast. So even if these civil damages are capped at $20,000 if it's the first offense, you could be looking at 6 figures plus in attorney's fees. And then a smaller amount would be court costs. Court costs tend to be things like the cost of service, filing fees, things like that. Those are smaller. So the big concerns are those civil damages and also those attorney's fees. And that's kind of what you should keep in mind when you're deciding whether or not you really want to push back on a claim or not. If it's a situation where it's unclear from the guidance or from case law what a court or what an agency would find, this is the balancing test that you want to look at. And I think it's important to know that, one of the things we do, if we're unclear when we get the question, we'll try to reach out to somebody from HUD or somebody from the TWC before a complaint is filed and say, hey, we're dealing with this case. We don't know what our client needs to do. How would you handle this request? And a lot of times, they'll more often than not say you need to grant this accommodation. and they'll make some recommendations that, you know, most people would think were a little strange, or but the reality is those agencies exist to serve these disabled individuals, and they skew very heavily towards the benefit of those individuals over their neighbors or the communities that they live in. And I think that brings us to the question and answer. If I'm correct, we have some questions submitted in the Q&A. Clayton, do you want to just kind of take those one at a time? I see a question about whether or not social workers can diagnose people, which I can speak it. So before I made the very expensive and time-consuming decision to go to law school, I was a social worker. Social workers can't diagnose people, but if they are aware of the existence of a diagnosis by a medical professional, the guidance suggests that a social worker can provide the documentation needed so they can opine as to the fact that this person has been diagnosed with this condition, and then they can kind of speak towards whether or not that person needs an emotional support animal. So
yeah, and to work off of Ashley's response to that question, which was submitted, the House Bill 801 that I spoke of does specifically list social workers as people who can attest to the disability. While, you know, my typed answer or my short answer to this is yes, they can. In a medical sense or in other contexts, a social worker is surely not qualified to make a diagnosis. Oddly enough, this is like your social worker panel. Before law school, I was also a social worker. And I don't feel myself currently qualified to diagnose a mental illness, although we've all had homeowners that we plainly and clearly could refer to as crazy. Our evaluations in that regard are not binding. Neither are social workers, but a social worker can write a letter that would support an emotional support animal. So thank you very much for that question. We have another question from the same audience member. And the question is, we have a person claiming they don't have to provide any medical evidence because of medical privacy under HIPAA. It seems that's not a defense. Well, that's why when we were talking about what level of detail you can request from the provider or from the homeowner, you can't just say, I need all of your medical records, or I need your treatment notes, or I need to know what kind of pharmaceuticals you're using to treat this as an alternative to this emotional support animal. If you've seen a request for an accommodation, usually the supporting documentation goes something like, hello, my name is Clayton Hearn. I'm a therapist licensed in the United States Samoa. I am treating Ashley for anxiety disorder, and the cat, which is now registered, by the way, is an animal that helps alleviate some of the symptoms of that anxiety disorder. That is the level of documentation you can require. You can't really peel back and question that or get a second opinion. So HIPAA wouldn't apply because you're not really giving out, you know, medical records or anything like that. So so that is an insufficient response to your request for support documentation.
There's a question. I think the next two are kind of related. What rights do the people living around these individuals have when they can't go outside? One says due to the smell, and the other says that, you know, chickens are crowing every morning. Is that reason enough to deny their presence? And the reason I picked this one specifically is, we got a similar question recently. It was one where a complaint has not been filed, so we reached out to a connection at the TWC, and his response was, has the association talked to this neighbor about soundproofing their home? That was the response that we got. And we all kind of balked at that. Nobody was expecting that sort of response, but the reality is that's pretty in line with what we've seen from the TWC and HUD in the past. You know, I guess their approach is, we're not here to make sure everybody around these people are comfortable. We're here to make sure that this disabled individual that fits in within this protected class isn't being denied their housing rights. So the TWC would say, you know, you still, you know, they have, I would argue they have the obligation to keep the property sanitary. That's, you know, it's not unreasonable to say we're going to let this, you know, area become a health hazard, but either TWC would turn around and say, you have to let them have this animal. They have the doctor's note, and really it's up to the owner or the owners and neighboring properties to adapt. And that's unfortunate, but that's the guidance we've gotten so far. Of course, like I said, that was one where a complaint hasn't been filed. It's not guaranteed that the investigator we spoke with would be the investigator assigned. We don't know for sure that that's what would happen, but we have, I mean, that's the response that we've gotten so far. So that's what we've had to go with. Let's see.
I have another question, and I think this is a good illustration of some of what we spoke about. And the question is, we have a limit of 2 dogs. Could someone have additional dogs by registering them as ESAs to get around the 2-dog limit? Unfortunately, the answer to that is yes. We often get a situation where a certain number of pets are allowed, and then you have emotional support animals or other assistance animals that are also in the house. You cannot aggregate the assistance animal with the pets to go over a limit. So these are not treated as pets. So yes, that's how people could squirrel around the rules. And, you know, to an extent under the law, it is legal and proper if there's a legitimate need for it.
We have a question about responsibility for costs. Who's responsible for the cost of the accommodation? Looking at HUD guidance, it looks like the person is responsible for the cost of modifications on their own property, but not the common areas or elements. Modifications are a little different from accommodations. Modifications involve like a change to the physical structure of a common area or of a home. So, you know, the most common example is, let's say somebody wanted to have like a wheelchair ramp installed. That would be considered a modification as opposed to an accommodation. So the rules are a little different, but that general statement is typically correct. Well, the owner would be responsible for modifications to their home site, and the association may be responsible for the cost of accommodations to the common elements. There's some nuance to that, so it really would depend on the individual request.
Okay, I see a question that was posed, and I like this question. I'm glad someone asked it. It's the common area also include on-site association and designated eating facilities. And the question is when an ESA animal tends to want to wander around and sniff at people's food and look out of their drink cups and stuff. Ashley and I actually did work on the same case that she described, as the woman who had vertigo didn't have to keep her dog on leash, but one of the issues and the reason why it came to our desk was that the dog was going around sniffing and licking at people's drinks in the pool area. That kind of behavior is not allowed, because even though it's not a direct threat as far as maiming somebody, a dog licking at your cup is a health issue. So that would fall under the direct threat in safety and welfare issue. So we don't have to allow dogs to go around eating your food and sniffing and licking your utensils and such. So at least that would be my view on it. A more conservative view would be, you know, well, why don't you share with the dog?
I think, yeah, I mean, I think you don't have to allow that sort of behavior, but you know, if the person can get their dog under control, keep them on a leash, then you may have to still allow them to be in that common area. So
I'm going to try to get to a few of these questions. It looks like we have 6 minutes left. So here's one. So the requirement for the animal to cause physical damage means the damage to property values is not a reasonable cause for exclusion. Unfortunately, when they talk about physical damage, they do talk about destruction of physical property. The property value is more of an abstract concept. I would love to be able to test that theory, but I would like to do it more in the defense context where someone's already taken this position and I get to defend it. I wouldn't recommend that any of you be the sort of guinea pig or test tube baby for this, because like Ashley alluded to, it can be extremely expensive to litigate these issues. And in something like that that hasn't been established in your favor, bringing property values as akin to physical damage, I would prefer that none of you go in that direction prospectively. But I would like to defend that case if someone's already done it and it gets to my desk. So thank you. It looks like we're running short on time. Do we have time for another question or two? Ashley, you have a favorite question on here?
Let's see. Oh, what if any are the rights of residents who have allergies to animals or are exposed to ESAs in common areas? We dealt with this question recently. And we don't really have anything from HUD, and we don't really have anything from Texas case law, but there is case law from other states that suggest it depends on who got there first. So, and the person with the allergies was already living in the home when the person brought the emotional support animal that triggers their allergies in theory, you wouldn't have to allow the animal. But like I said, that's case law from another state. You can't really guarantee that that's how it would be applied here. Just an interesting tidbit.
And I have actually run into that question in the employment context, which is very analogous to the housing context. And someone wanted to bring an animal in, and there was an actual allergy of one of their coworkers to the animal, and the brilliant people with our federal government said, we'll just put them in different facilities or different buildings. Okay, I don't know how large a company all of you work in. There are big, some big companies and small companies. My office here in Dallas really wouldn't allow for the relocation of a person to avoid allergens. So in short, they punted on the question, didn't really answer it in a way that was practical to my client. So we don't have any guidance. Probably the best guidance we can give you is first come, first served, like Ashley alluded to earlier.
Right. We have like 2 minutes.
And somebody asked if a doctor can prescribe more than one animal.
Yes.
And someone had too many ponies. And as silly as that sounds, if it's under the auspices of an emotional support animal, we've had cases like Ashley discussed earlier, where not only a chicken, not only 2 chickens, not only 3, but 6 was found to be reasonable. So it can be multiple animals. I would like not only the state legislature, but our federal legislature to sort of address these, because I could probably find a doctor online today saying that Clayton Hearn needs 20 dogs. So maybe not 20, maybe 10, but still, it can get ridiculous when we don't have any kind of numeric limits.
I think we're probably out of time. There are more questions left. I think our contact information might be, I know it's for sure on our website, but I think it might also be available on this slideshow. If, always feel free to reach out to us, or if you have any questions, if you're ever unsure about a fair housing question, certainly reach out to your attorney. It's not always, it's not always obvious what the rules are, and, we're here to help. So.
Thank you so much, everybody, for attending. We've enjoyed talking to you. This is a topic that we truly enjoy. Sometimes we find it tedious, not not because of the topic in the area of law, but when someone needs 6 chickens or somebody needs a dog that runs around sniffing on people, it does get out of hand. And we have some compassion for all of you who have to deal with these requests, which are sometimes a little bit over the top. So give us a call. We love to talk on this subject. Our contact information is on our website, and please join us for the upcoming webinars that our firm is giving. And thank you all so much.